Legal Breeze welcomes you all for yet another discussion which is relevant because we are all undergoing the election climate as of now, particularly a few states going for the general election. So, in this background, the topic for today's discussion assumes more importance. I am sure by this time you would have guessed what we are going to discuss. Your guessing could have been perhaps right. We would like to discuss about the electoral bond scheme. Electoral bond scheme has been announced by the then Finance Minister Sri Arun Jaitley in the year 2017 as part of his budget speech. In the Finance Act, he brought a chapter called Transparency in the Process of Electoral Funding. Unfortunately, this is only the title. It never promotes transparency. We all felt very happy, oh God, because this scheme eliminates the cash-based transaction. So we felt very happy about it because you cannot give cash as a donation to the political parties. It has to be given only through check, demand draft, NEFT or other digital transaction by which you can purchase a bond which will be similar to a promissory note issued only by State Bank of India. Even RBI cannot issue this. And this is something like uncrossed check. Anybody can encash it. But since it is an electoral bond, this can be for any denomination, starting from 1,000 rupees to 1 crore, several crores. It is up to your ability. No commission is being charged. So that extent the donor is protected. His name will not be disclosed. It is 100% confidential. It will be anonymous. And he can donate this or you can give this particular electoral bond to any political party he likes it. The political party has to encash this electoral bond within 15 days from the date of the issuance of the said bond. If the political party couldn't encash the same, it will automatically go to the Prime Minister's Disaster Relief Fund. Idea is very novel. There is no doubt about this because there is no cash-based transaction. It is totally eliminated. But the problem, it gives only advantage to the ruling party because SBI is not extra constitutional authority. It is not above the constitution. It is not above the government. It is not above the RBI. People can track it. Particularly, even the SBI cannot share the details with the RBI, but they can, if it necessary, it can be shared with the government. So, an important question has been raised. I think I should ask this question instead of let me come back to that question a little later. I have a question. SBI is functioning under the RBI. So, any bank which is functioning under the overall regulatory and supervision of RBI, can they perform any function which cannot be monitored by a regulatory authority? So that itself, it violates RBI Act and other banking business per se. So it will be ultra virus to that extent. It will be unconstitutional to that extent. On the other hand, the Supreme Court, instead of staying this electoral bond scheme, very recently it has pronounced an order, thanks to the Association of Democratic Rights, ADR, through their continuous legal battle, they have brought number of electoral reforms, including today we all have a right to know about the criminal antecedents, the assets, educational qualification of the prospective candidates or prospective parliamentarians or legislators. It is applicable, I think, even to these Panchayat Raji members. So that's a great success. That success can be attributed to the Honorable Supreme Court and the ADR because it is they who have fought for all these electoral reforms, the same organization is also fighting against this electoral bond, against the might of the state. The previously election commission has opposed this. Many constitutional bodies have opposed this. Now, what mantra has happened, we do not know. They all had a change of mind, including the Attorney General. They are all supporting the scheme before the Honorable Supreme Court. Supreme Court has raised an alarming question whether this money cannot be used for terror funding. Whether this money cannot be, is there any mechanism that to ensure that this money is not used for creating violence or incite against the government, thereby it creates a peace and tranquility problem in this country. Government has not answered all these things. It has also removed the corporate limit for donation. Previously, I think up to 4% of your net profit for the past 3 years can be donated. The average of your 3 years net profit, out of that 4% can be donated maximum. That limit has also been removed now. So you can donate any number of percentage. So whether the corporate will give free lunch, necessarily it cannot be done. There is no free lunch today. Particularly corporate, they will do for business. Whether the business is ethical, certainly we welcome it. In fact, there is a controversy about the Vedanta donation to the political parties. Vedanta is a foreign subsidiary. You all know it is engaging in the mining business. There is a controversial case against it called Odisha Mining Corporation and others versus Union of India. Way back in 2014, the Supreme Court has heavily come down against not only the corporate, that is the Vedanta steel factory, but also against the various governments, including the state government, for violating the Tribal Rights Act, completely violating the Forest Rights Act and Environment. Mining lease has been granted to that company. So what it shows, when you funding them, naturally you can expect something from quid pro quo from the whatever government which is on the seat. It has been proven not only in India, it has been proven elsewhere, even the countries like developed countries like UK. There is a cash for query scam has happened, LAD scam has happened. Just for raise some questions in the parliament, MPs have been paid, bribed. It has happened in our own country. Thanks to Mr. Somnath Chatterjee, the then Lok Sabha Speaker, he has expelled all the members outrightly. And these are the electoral reforms pending as of now. We do not know what way the court will interpret, but we all hope that the court will come up with the right sort of interpretation, upholding the constitutionality of free and fair election, because free and fair election is a basic structure of constitution that cannot be even amended by the parliament. So there is a saying called, little man takes a little pencil, walks into the little booth, makes a little marks across the little slip. That determines the might of the politicians. This is a statement given by Winston Churchill. So whether the court is going to honor the little man like you and me, or the giant corporate and the mightier political parties, because the political parties are consistently refusing to come under ambit of public authorities under the RTI. So there is no transparency. Transparency is the need of the hour. Transparency and good governance are part and parcel of directive principles of state policy as well as fundamental rights. We hope the good sense will prevail over sooner rather than later. God bless you all. Jai Hind.